Hello and welcome. I am Mahmudul Hasan, your trusted immigration attorney. Today we are talking about changing or leaving your H-1B employer. If you are in H-1B status and thinking about switching jobs, wondering about your options after termination, or trying to figure out what happens to your green card process if you leave your employer, this video is made for you. Let's dive in. What is porting in H-1B and green card cases? Let's start with the common question, what is porting? You might have heard people say they ported their H-1B or green card process to a new employer. But what does that actually mean? There are two kinds of porting available under US immigration law, and they apply to different situations. First, there's H-1B petition portability. If you're an H-1B worker and want to switch jobs, you don't have to wait for your new employer's petition to be approved before you start working. As soon as your new employer properly files a new H-1B petition, Form I-129, requesting to transfer or extend your status, you're allowed to start working for them right away. No waiting, no employment gap. More details about this are available on the H-1B Specialty Occupations page on the USCIS. The second type is immigrant worker petition portability, which applies to green card applicants. If you have a pending I-485 adjustment of status application for at least 180 days and an approved I-140, you may be able to transfer your green card case to a new job offer as long as that job is in the same or similar occupational classification as your previous job. For example, if you are a software developer and move into a role as an information systems manager, that might be considered a same or similar job, allowing you to port your petition without starting the entire green card process over. This process, sometimes called INA 204J portability, requires you to submit Form I-485 Supplement J to USCIS, which confirms that your new job offer meets the eligibility criteria. Now, if your I-140 was filed under a national interest waiver or as a person of extraordinary ability, you don't even need a job offer to continue your green card process. That is one of the key benefits of those categories. How can I leave my current H-1B employer and start working for a new one? So let's say you found a new employer and are ready to switch jobs. How do you leave your current employer while maintaining your H-1B status? The good news is that H-1B portability rules allow you to start working for a new employer as soon as they file a proper H-1B petition on your behalf. You don't have to sit around waiting for an approval notice before you can start your new job. As long as the petition is properly filed and not frivolous, you can start working as soon as USCIS receives the petition or on the requested start date, whichever is later. However, there are some risks if your new employer's petition is denied. In that case, you'd have to stop working immediately. If you're considering an H-1B transfer, always work with an immigration attorney to make sure everything is filed correctly. What are my options if my H-1B employment is terminated? Losing a job is stressful, but if you are on an H-1B visa, it can feel even more overwhelming. A lot of workers wrongly assume that they have to pack their bags and leave the country immediately if they get laid off. That's not true. If your H-1B employment is terminated, either voluntarily or involuntarily, you usually have up to 60 days to take action. During this grace period, you may have the following options. 1. Find a new employer and have them file an H-1B transfer petition. 2. Apply for a change of status to another visa category if eligible, such as F1 student. 3. Apply for adjustment of status, green card if you are eligible. 4. Apply for a compelling circumstances employment authorization document, EAD, if you qualify. As long as you take one of these actions before the 60-day grace period ends, you can stay in the US beyond those 60 days, even though you are no longer employed by your original H-1B sponsor. However, if you don't take action, then you and any dependents must leave the US before the grace period ends or by the expiration of your current H-1B status. Whichever comes first My employer filed a Form I-140 on my behalf. What happens if I leave my job or if my employer withdraws the I-140? Will I retain my priority date? Am I still eligible to adjust status? Let's talk about your green card process. If your employer has filed an I-140 immigrant worker petition on your behalf and you decide to leave that employer, what happens to your case? Do you lose everything? The answer depends on how long your I-140 has been approved. First, if your I-140 has been approved for less than 180 days and your employer withdraws it, USCIS will automatically revoke it. However, you won't lose your priority date unless the revocation is due to fraud, misrepresentation, or an error by USCIS. Second, if your I-140 has been approved for more than 180 days, your employer can withdraw it, but it won't be revoked. That means you keep your priority date for future green card applications. You can extend your H-1B beyond the 6-year limit as long as you are otherwise eligible. Your spouse, if on H-4 status, may still be eligible to apply for an employment authorization document. If your priority date becomes current and you have already filed an I-485 adjustment of status, then after 180 days, you can port your case to a new employer in a similar role without needing a new I-140. My employer filed a Form I-140, but I would like to leave and focus on my startup. Can I port to self-employment and still adjust status? What if you want to start your own business while waiting for your green card? If you have a pending I-485 for at least 180 days and an approved I-140, you may be able to port to self-employment as long as your new job is in the same or similar occupation. But here's the catch. USCIS will scrutinize self-employment cases very closely. You'll need to prove that your business is legitimate and that your role matches your previous job in terms of responsibilities, required skills, and salary. If USCIS has concerns about fraud, they may ask for additional evidence. I have an approved I-140, but I know I will be waiting a long time for a green card. Do I need to keep my I-140 valid the entire time I'm waiting? No, you don't need to maintain an active approved I-140 the entire time you're waiting for your green card. Once you have an approved I-140, your priority date is locked in, meaning you can switch employers, and even if your original I-140 is withdrawn, you can use your priority date with a new I-140 from another employer. You only need an active I-140 when you are ready to file Form I-485 for your green card. What if my employer retaliates against me? What protections do I have? If you believe your employer has retaliated against you, whether by threatening your status, failing to pay you properly, or even trying to prevent you from changing jobs, you have rights regardless of your immigration status. In some cases, USCIS may allow exceptions for H-1B workers who lost status due to employer retaliation. If you can prove that you reported a labor condition application (LCA) violation and your employer retaliated against you, USCIS may excuse your failure to maintain status and allow you to extend or change your H-1B status on a case-by-case basis. If you believe you've been retaliated against, it's important to know your rights and seek legal guidance. Changing jobs while on an H-1B visa can be a stressful process, but it doesn't have to be. Whether you're switching employers, dealing with job loss, or thinking about your green card options, knowing your rights and taking action early can make all the difference. If you have questions about your situation, always consult an immigration attorney to ensure you're making the best decision for your future. Thanks for watching, and if you found this information helpful, don't forget to like this video, subscribe, and stay informed about the latest immigration updates. See you in the next video.